Hello, I'm Katrina Crooks and I'm a partner in the Dispute Resolution and Litigation team at Shelston IP. Today I'd like to talk to you about patent enforcement and in particular how the law of novelty can save a potential infringer from otherwise being found to infringe a patent, which can be an expensive business. So what is the law of novelty? Well, in simple terms, in order to be valid, a patent must be new or novel over what is called the prior art that existed at the time the patent was filed, or in some cases an earlier priority date. This means that if the subject matter of the patent was published or used before the relevant date, the patent can be found invalid. Often it's argued that the subject matter was disclosed in an earlier patent document. In order to show that the patent is invalid on this basis, it's important to show that each and every feature of the patent claims was disclosed. In some cases, a novelty argument is raised before a patent is granted, and if successful, the patent application will be refused. But sometimes the Patent Office will not become aware of a relevant document during the application process, and a novelty argument can be raised at a later stage. A patent can be invalidated at any time during its life, and commonly, if an infringement claim is brought against another party, that other party will claim that the patent is invalid on the basis that it was disclosed before the relevant date and therefore was not novel. That's the theory. So now, let's examine a landmark decision which was handed down in Australia last year, that's 2013, to see how the courts have considered the law of novelty in practice. First, some background facts. Danisco and Novozymes are both biotech-based companies headquartered in Denmark. Danisco owned a patent which claimed a process for preparing a foodstuff, including the addition of an enzyme to a food material. In 2011, Danisco sued Novozymes for patent infringement in respect of its product, which was called Lipopan Extra. Novozymes counterclaimed, challenging the validity of the patent on a number of grounds. One of the grounds was that a document referred to in the Novozymes patent disclosed all the features of the claims of the Danisco patent. Danisco argued that one feature of its patent was not disclosed in the earlier Novo patent, namely that the monoglyceride acted as an emulsifier. Novozymes argued that even if the features of the Danisco patent were not expressly disclosed in the Novo patent, the inevitable result of carrying out the instructions contained in the Novo patent would be a working of the process claimed in the Danisco patent. That is, the monoglyceride would act as an emulsifier. At first instance, the court accepted that a prior publication which contains a direction to do something which inevitably results in something within the claim in question may deprive the claim of novelty. This conclusion is derived from a 1972 English Court of Appeal decision known as the General Tyre and Rubber Company case, which has been applied by the Australian courts on numerous occasions. However, in the Novozymes matter, the court held that where a claim relates to a process with identified results, novelty will only be destroyed where, firstly, following the instructions in the earlier publication will inevitably produce the identified results, and secondly, those results would be understood to have occurred by a person skilled in the relevant field. So in the case of the Novo patent, the instructions contained in it had to inevitably produce an emulsifier, and the skilled person had to understand that this was the case. The court found that these conditions were not met in that case. Novozymes appealed. In February of 2013, the full court of the Federal Court of Australia handed down its decision and upheld the appeal. In doing so, the court found that the novelty of a patent may successfully be challenged even if the invention is not expressly disclosed in full in the earlier document, as long as the inevitable result of following instructions contained in the earlier document is the working of the patented invention. The full court did not impose the additional requirement that the skilled person have an understanding that this was occurring. As the court was satisfied that the inevitable result of following the instructions contained in the Novo patent was the carrying out of the method claimed in the Danisco patent, this was sufficient to invalidate the claims of the Danisco patent. The full court also considered whether the invention must actually be carried out or be capable of being carried out before the priority date, that is, the date at which novelty is to be considered. In this case, the Novo patent had been published only 1 month before the priority date of the Danisco patent. At first instance, the court concluded that practically there would not have been adequate time for the process to have been carried out before the priority date. This formed a further basis for the finding that the Novo patent did not anticipate the Danisco patent. However, this suggestion was rejected by the full court. It is the content of the information in the earlier document that amounts to anticipation, not the carrying out of the instructions contained in it. For patentees, this case is a confirmation that even though an earlier document may not expressly disclose a feature of a claim of a patent, the patent could be found invalid if it is an inevitable result. Close prior art, therefore, needs to be carefully considered from this perspective when assessing the validity of the patent and potential challenges to it. For parties who might otherwise find themselves infringing on a patent, the advice is to consider all possibilities for invalidating the patent, even where there may not be an express disclosure of a particular feature. Given the damages that can be payable for patent infringement and the possibility of no longer being able to sell a product or use a patented method, this is well worth investigating if patent infringement is asserted. I'm Katrina Crooks from Shelston IP. Thanks for your time.